Hello, everyone. Welcome to Washington Gun Law TV. I'm your host, Washington Gun Law President William Kirk. Hey, there's great national debate going on right now about red flag laws, and I thought it'd be a good opportunity for us to take a few minutes and discuss, do we have red flag laws here in Washington? And if so, how do they work? Well, thanks again for joining us today. Listen, if you like this video, please go ahead and click that like button down below. If you want to stay apprised of all issues related to your Second Amendment rights, especially here in Washington State, but on a nationwide level as well, go ahead and click that subscribe button down below. And again, always feel free to follow us on Facebook and Twitter. So today I thought we'd take a few moments and talk about red flag laws. Now, such laws, sometimes they're called red flag laws, are having a renewed interest here in the national spotlight. Unfortunately, as we are aware, there has been a series of mass shootings throughout the nation, and recently President Biden has directed the United States Department of Justice to publish a model legislation to make it easier for the 30 states in the country right now who do not have red flag laws to get those passed. Now, Washington has kind of been at the forefront of this issue. Back in 2016, through Initiative 1491, the voters in this state overwhelmingly actually approved our version of red flag laws, or what we call here in Washington State, extreme risk protection orders. And the law surrounding Washington State's extreme risk protection orders is now codified in RCW 7.94, the links of which are down below in the description box. So in addition to allowing law enforcement to seize and confiscate the weapons of otherwise lawful and responsible gun owners, extreme risk protection orders will also require that that individual forfeit their concealed pistol license. And in addition to that, any person who has an extreme risk protection order granted against them will be placed on a national no-sell list, which is available to all licensed FFLs throughout the nation, thus making it impossible for them to purchase any firearms while that order is in effect. Now, juveniles, anyone previously convicted of a felony, anyone who's been previously arrested or convicted of a domestic violence, those that are subject to domestic violence protection orders, anti-harassment orders, or anyone who has been involuntarily committed into a mental institution for a minimum of 14 days are not legally allowed to possess firearms anyways, so the extreme risk protection order does not apply to any of them. Also, an interesting note, as of January of this year, anyone involuntarily committed for up to 5 years also loses eligibility now to legally possess a firearm. But an extreme risk protection order, or ERPO as we call them here in Washington State, is for all other individuals who otherwise are completely and lawfully allowed to possess firearms. So let's talk a little bit about how this process works. Presumably, a law enforcement officer or a concerned family member would file the petition. In Washington, only law enforcement officers or a member of the respondent's family can actually file an order, a petition, I should say, for an extreme risk protection order. Now, the petition must include evidence of recent threatening behavior or statements about harming themselves, others, or a combination of the two. The petition must also point out the location of all of the respondent's firearms and whether or not that respondent possesses a valid CPL. Now, interestingly, under Washington law, a person can file for an ERPO, an extreme risk protection order, even if the respondent does not currently own any firearms, but only if they have expressed an interest in becoming a firearm owner. Now, in many states, only law enforcement officers can be the petitioner to these orders, but in Washington State, the law is a little unique that either law enforcement or members of the respondent's family can petition for the order. Interesting also to point out that anybody who files a false extreme risk protection order petition can and should be charged with a gross misdemeanor. Now, here's how the actual process works. The petitioner, the person who is concerned for the other individual's safety, would file a petition with the court ex parte, and that's fancy Latin for hearing just from one side. The order would obviously have to demonstrate a pattern of conduct of threatening behavior and the person's access or potential access to firearms. If the court believes there is sufficient evidence to grant the order, the court will issue a temporary order that lasts for 14 days. Now, I previously stated that this order would be petitioned by ex parte, which means the person who's asking for the order has the ability to go to court and present only their side of the case. The respondent, the person who would theoretically have the firearms removed from their home, does not have an opportunity to respond at this temporary order hearing. If the temporary order is granted, law enforcement will be notified immediately. The law enforcement would then go to that individual's homes, confiscate and seize all firearms, including their CPL. Now, within 14 days of the temporary order being issued, the court will hold another hearing to determine whether or not a full permanent order goes into effect. And at that hearing, both the petitioner, the person who is asking for the order, and the respondent, the person who is subject to that order, are both allowed to be present and present as much evidence as the rules of evidence allow to either in support of that petition or in opposition of that petition. The court will determine at that hearing, and only the judge will determine whether or not an order becomes permanent. If an order does become permanent, it has a duration of 1 year. The order will expire in 1 year. However, the law requires that the state notify the petitioner, that is the person who originally asked for the order, within 105 days of the expiration of that order. If the petitioner so desires, they can petition for the order to be extended. However, that petition will only be granted if the petitioner can show that the original concerns have not abated and that the conduct is ongoing. Oftentimes, you will see attempts to extend an order where the person may still be scared about the previous conduct, but there hasn't been any other instances of that conduct. And in those situations, the court should not extend the order. In reality, most orders do last 1 year in duration, and very few are actually extended beyond that time. Now, as previously mentioned, extreme risk protection orders or red flag laws are becoming more nationally prominent right now as the Biden administration, through the Department of Justice, is clearly pushing their agenda on the 30 states that currently do not have red flag laws in place. Now, as we talked about earlier, Washington State has had these laws in effect since 2016. However, we're seeing the use of these laws and these petitions and orders increase significantly. For example, in 2020, in King County alone, we had 79 extreme risk protection orders that were filed for. That was up from 67 in 2019. And as of March, which is the last data that I received, there had already been 12 ERPOs filed for in King County. Other data shows that as of September of 2020, 521 extreme risk protection orders have been filed for statewide since the law went into effect January 1st of 2017. Although in some counties, 12 of them to be exact, there had not been a single ERPO filing. And this is according to the University of Washington's School of Social Work. Well, I hope that helps clarify Washington's red flag laws or our extreme risk protection orders. This issue is not going away. It's going to remain a hotly contested, debatable item here as to our Second Amendment rights, with the current presidential administration certainly trying to force their agenda upon a lot of lawful and responsible gun owners nationwide. Listen, you may have more questions about extreme risk protection orders or anything related to your Second Amendment rights, either on the state level or the national level. If you do, don't ever hesitate to contact us at WashingtonGunLaw.com. You can always email me directly, William@WashingtonGunLaw.com, or of course you can give us a call at 425-765-0487. Listen, part of being the lawful and responsible gun owner, like we preach here at Washington Gun Law, is knowing what the law is in every situation and how it applies to you in every instance you may find yourself in. Until next time, thanks for watching and stay safe.